Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have. What's up, everybody? We're back at it. Sorry for a little bit of a delay in the start. We had some technical difficulties with the mic, but I think we got it figured out. So we are here talking more Johnny Depp today. I'm going to give a little bit about what's going on, what news we've heard, what's some new stuff that's coming out. We'll talk about the picture that the judge is apparently not letting in. We'll talk about all that. And then the main part that we'll do before we get to the Q&A is talk about hearsay, all the exceptions to hearsay, and why certain things are coming in and other things are not that seem like hearsay. And then I'm also going to talk about just like how a trial lawyer has to balance the rules of evidence, and it goes through a grinder. Like every piece of evidence, every statement, every document, it goes through a grinder. It's not just hearsay. We look to all of the things we talked about on the first show of this week, which is why certain things come in and out. They got to be relevant. They got to be authentic. They've got to be admissible, and all the different ways lawyers can object to pieces of evidence. So we'll talk about that some today as well. And then, of course, as always, we will get to the question and answer portion at the end of the video. So if you haven't already, take a second, hit that like button before we get really into it. Make sure you're subscribed if you haven't already. We did hit 75K, so we'll be posting a giveaway on our community page. You have to be a subscriber to win, so make sure you subscribe before you post on there. And we're getting close to making some plans for 100K if we're able to get there before the trial ends. That, you know, could be fun. So we'll see what happens. We'll see what happens. We want to count our chickens before they hatch, right? Yesy, thanks for subscribing. I see some new subscribers already in here, which is awesome. And to start out, let's talk about trial by TikTok, trial by YouTube, trial by Twitter, right? Which is some of what's happening in this trial. And as somebody who makes YouTube videos for fun, you would think I would love that, right? And think that's a great thing. And somebody that writes a blog reached out to me to talk about this, and that was one of her questions. And I think that she had a big problem with it, and I understand why she had a problem with it. I said I was going to shout out Dustin from Alaska that emailed in to me and asked for a shout out. And Alejandra, I see you're a new sub and you asked a question. The questions people post a bunch of questions now. We'll star a bunch of them and talk about them at the end. But the trial by TikTok and YouTube and all this stuff, I want to say, be careful. Just be careful what you're looking at. Be careful how hard you go after somebody because of something you saw on TikTok or YouTube or anything, no matter who it is. Elizabeth, thanks for the new sub. Make sure that you take it with a grain of salt, which is why I always say, let's focus on what comes out in court. And all I really comment on or try to stick to is what comes out in court. Because I've seen some stuff get sent to me on Twitter and TikTok, and it's fun, and I don't have a problem with you guys sending me stuff. You say, hey, what do you think about this? But most of that stuff is fake or doctored or unreliable, and that's why it's not coming in. And people have a big problem with why a lot of this stuff is not coming in. And the point is, most of it is illegitimate. So let's not spread stuff that we know is fake, right? And let's not jump to conclusions on things that might be fake. So I just want to put that in everybody's mind as they kind of think critically about this trial and what evidence comes in and why certain things come in and certain things don't, because we want to stick to what happens in court. And there are rules of evidence, and the judge is the gatekeeper to only allow certain information to come in. So I don't want to spread fake hate and fake stuff that makes people hate Amber Heard or Johnny Depp or overly in support of one of them because of a TikTok video or because somebody's pointing to a hand or a lip or whatever it may be in a certain video. Now, we talked about the James Corden interview in the last video or 2 videos ago, which we took down, by the way, because we got a copyright strike. So we took down that little clip we pulled from the James Corden show, but the discussion is still the same. If you can use something that's from somebody else, meaning James Corden, and not edited and use it to look at it, I think that's fair. But people that edit it before they post it is difficult to determine whether or not that stuff is true or fake. So the reason I'm bringing this up is because I've had so many people tag me in the Talented Mr. Ripley quote. And a lot of you guys are from Rekieta's channel or Legal Bites, and I've gone on there during the trial and will continue to do so. And I actually tried to look at Rekieta's stream. I can't remember what day it is, but it was the first day Amber Heard was where this testimony came out that was similar to the Talented Mr. Ripley. And I said it immediately on, I think, I'm pretty sure it was Rekieta's channel that I was watching it. And I said, man, that sounds exactly like Talented Mr. Ripley. When I said that, I meant the sentiment was the same. It was clearly different words. It was not word for word quotes. Yet that's what I'm getting on Twitter is, can you believe she quoted word for word, or you called it, she quoted Talented Mr. Ripley. She did not quote it. And I'm going to look for that. And I'm going to put it on my channel, a clip from Rekieta's show. So if he wants to copyright strike me, it's going to come from him, which I don't think he will do. And I will donate more of my time to his channel because he's a good dude and I enjoy being on his channel. But I just know we all had that discussion. So I want to bring it up to show you how this stuff is kind of fake and people are going overboard as saying she's quoting movies when in reality it's just similar sentiments. And if you want to say she got ideas from movies, fine, we can discuss that. But quoting movies is kind of tough for me because that's not really what I saw. So, okay, that's kind of just the little PSA in the beginning. Let's get to it now. So, update of what's going on. The judge has kept out the photo of Amber Heard's split lip. And it seems like the reason the judge is keeping it out is because they didn't produce it in discovery or didn't give it as an initial exhibit when they did their exhibit list exchange and exchanged exhibits, which is when you have to give this stuff. It's not a trial by ambush. We don't surprise people in the civil justice system. We want both sides to have all the information so that if they want to settle and resolve the case, great. But if they don't, at least they know what's going to be coming out at trial, because there are things in place that we do, like making proposals for settlement, where if you make the wrong call, you could pay the other side's attorney's fees and costs. So we need to know all the information in order to be able to make educated decisions throughout the case as the client and the lawyers. So when we talk about not producing it, that's why it's not coming in. Not necessarily because it's not authentic or because it's not fitting the timeline that Amber Heard wants it to fit. And that's what a lot of the reports have been. The timeline doesn't fit with when she split her lip to when she's saying she split her lip, and this had to be here because we saw her on the streets, or this is when the picture was taken, this is when the magazine came out, whatever it may be. That doesn't seem to be the reason why it's being kept out. So when we talk about why certain pictures were allowed to come in, even though the metadata wasn't given, even though the judge ordered them to give it, but that one is not. It's not because it's less reliable necessarily, but it's more because of the timing of when they produced it. So the judge is at least trying to play gatekeeper, and I think that's important. But I've also had a lot of questions as to, well, if you were Johnny's lawyers, wouldn't you want that picture to come in? Because you could disprove it with the timeline. You could disprove it by saying, here's when you say you were hit, and here's when this picture was taken. And while I agree with that, I would say you're starting to get into the mind now of a trial lawyer and the decisions we have to make. Do you want to let in potentially damning evidence in hopes that you can flip it and use that evidence to prove your point and prove a point for your client by impeaching the witness on the stand with this evidence, and take the chance that either it falls flat, the jury doesn't understand it, the judge cuts you off in the middle of your questioning, and you're not able to impeach and flip that evidence as much as you thought you were, and now you've let that damning evidence in? The answer to that is usually no. You don't want to take that risk, which is why most of the time the first step on this type of evidence is let's try to keep it out as the lawyer if we think it's inadmissible or violates some rule or was disclosed too late. So I also think in this case, they have plenty of other evidence to try to impeach and show the timeline and do all that. You don't want to let another piece in. So you never let something in, even though a lot of people out in the community and in the public think, oh, they should have let it in because they could have destroyed her with it. So you don't always want to take that chance as a trial lawyer. Okay. Exceptions to hearsay. Let's talk about some exceptions, right? We're not going to get to all of them. There's a million of them. But the few I want to talk about actually apply to this case, and we've heard a lot about it, and I think the judge has actually made some incorrect calls. So when you hear your hearsay objections now, you can think, does this fall into one of these exceptions? The first one is present sense impression, describing an event or condition contemporaneously or right after experiencing it. Okay. And that's the important parts is the timing. The timing is most important. You don't have enough time to make up a lie. You don't have enough time to change your story. And the whole point of hearsay is keeping out unreliable evidence. We want it out. But if its reliability can be proven based on the timing of when you said it, then it's an exception to hearsay and it can come in. And I think the judge has missed some of this, even with Amber's own testimony or Amber's own statements, her describing her mental state at the time, or somebody saying something to her to describe what they're thinking or what they're sensing. And another thing I want to say about hearsay exceptions, a lot of them cross over, which is why you'll hear lawyers arguing, well, judge, it's present sense impression, or it's excited utterance, or it's multiple things. It's then existing mental state, because we do everything we can to try to say it fits into one of these exceptions. And you'll hear as I describe some of them, they sound kind of similar and they have similar purposes. It's because we want only reliable evidence to come in. The next one is excited utterance. And it is exactly what it seems. Something you say when you're excited. Something happens to you. Like there's blood everywhere when Johnny Depp's finger gets cut off, or a security guard sees it and they say, oh, there's blood everywhere. That's an excited utterance, but it can also be a present sense impression. Their blood got on me. Was my impression. This is what I thought. This is what I sensed. I felt blood on me. When a startling or shocking event happens, directly following it can be an excited utterance. And the timing, again, is very important with that. The next one is then existing mental state or emotional state or physical condition. And that's just something where you're describing how you're feeling, thinking, physically, mental state in that moment, such as being afraid or being in pain, or something making you sick. Like we heard Isaac say, it made me sick, or this makes me sick. Or if one of her friends said, I know you're afraid. Those hearsay statements can come in because they're explaining someone's mental state or something that they're feeling. Now, we're going to get to how you can stack objections on each other, right? And how you can say hearsay leading, or hearsay relevant, or hearsay outside the scope of their knowledge, so that even if it is hearsay, you're trying to also fight the objection, like prejudicial, let's say. So it's hearsay, but even though it's a then existing mental state, it's more prejudicial than probative, therefore it can't come in. Next one that we talk about a lot in this case is medical diagnosis or treatment. So hearsay statements, when you're saying, yeah, my head hurt, I think I got a concussion because I got hit in the face by Johnny or whatever, that's coming in because it's for medical diagnosis purposes, and it's therefore more reliable because you wouldn't lie to your doctor, would you? They could prescribe you the wrong medication or give you the wrong medical treatment. So we think that they're more reliable in the law, and therefore that's what that exception's for. Another one in the Milani product launch is the poster child for this, which is business record. If it's kept in the normal course of business, made contemporaneously at the time, and made by someone with knowledge of the company procedure, it can come in as a business record, even though it's technically hearsay, going to prove the truth of the matter asserted from an out-of-court statement, which is technically hearsay. Because it's a business record, which you can do by affidavit or testimony, it's reliable and it can come in. Now, one of the big ones that's very interesting to me is reputation or character evidence. I've talked about it a lot throughout the trial, and it actually is an exception to hearsay. So if you're talking about somebody's character and somebody saying, well, Johnny's a really good dude, or Johnny would never do this, he wouldn't hurt a fly. So while somebody may say that, or somebody says, I talked to Johnny's wife and she said he was very gentle with her. Okay, hearsay statement going to prove that Johnny is gentle. That is an exception to hearsay. So that can come in under hearsay. But this is where you stack rules of evidence. And every state basically has a 404 type of evidence, or type of rule of evidence, which says that character evidence is not admissible to prove conduct. We call this propensity in Florida. In Virginia, it just says character evidence not admissible to prove conduct. A lot of people have problems with that. Say, well, if they've done it in the past, or if that's what everybody says about their character, then they must have done it and it should come in. Well, usually that's not the case. And usually it's inadmissible because it's not reliable enough, even though it may be an exception to hearsay. However, there are exceptions made which allow character evidence to come in. if the evidence of the person's character or character trait is not admissible for proving the purpose of the action in conformity therewith on a particular occasion, except in criminal cases where the accused or the victim's character is called into question, which can also be used in quasi-criminal civil cases, meaning a civil case that's based on criminal action, which this one could arguably be so, because there's a lot of abuse talk, even though it's defamation, which could also be quasi-criminal as far as fraud goes. So that could allow them to get into this character evidence. And they're each putting each other's character evidence of honesty at issue, which is another exception where specific instances of conduct can come in if the character trait of the person is an essential element of the charge, claim, or defense. The proof may also be made of a specific instance of conduct, such as a person on direct or cross-examination, meaning Johnny did this. This shows his character. Or Amber did this. And two of the major character traits that can be put on trial like this is honesty and peacefulness. Are they honest and are they peaceful? Are they likely to lie or tell the truth? And are they likely to be abusive and violent? Very interesting. All right. Judgment of a previous conviction can come in, even though it's hearsay technically. Thank you, Tarantula, Ravenblood. But these prior convictions can only come in, and I'm going to read these because we all know what we're thinking, right? If a judgment was entered after a trial or guilty plea, if the conviction was for a crime punishable by death or imprisonment of more than a year, if the evidence is admitted to prove any fact essential to the judgment, and when offered by the prosecutor in a criminal case for the purpose of other than impeachment. So it cannot just be an accusation or an arrest. Yes, it is complicated, and I apologize for everybody that's getting bored with this. We're almost done with this portion, but a lot of people asked about it. So that accusation and arrest can't just come in as a previous conviction because it was far from a conviction. But a lot of people asked, why can Amber Heard bring up Kate Moss, but Johnny Depp not bring up her ex? And I'd be willing to bet that Amber Heard was not allowed to bring up Kate Moss and tell that story, that she went rogue, that her lawyers probably told her not to say this, but she did anyways. And in my opinion, it fell completely flat, kind of what I talked about in the beginning. You don't want to take this chance because now if Amber Heard opened the door, I will tell you, okay, you all know I have not read everything about this case. I didn't know everything about this case when I came into it. I'm learning as the trial goes from what comes out in evidence. I had no idea what she meant when she said, when I saw the stairs, I had a flashback. And, you know, I thought Kate Moss. I had no clue what she meant. I assumed it was a negative connotation, obviously, but I had no idea that there was some accusation that Johnny Depp pushed Kate Moss down the stairs. I had no idea until you all told me that in the chat afterwards. So I think it very easily could have fallen flat with the jury and proved nothing. So she took this swing, potentially circumventing the rules of evidence and the rules that the court laid out before her, and potentially scored no points. So that's why you don't want to take those chances. And now Johnny Depp could potentially walk through that door and get evidence out that could have been inadmissible, but for her talking about Kate Moss. So we'll see. And I know a lot of you want to know about Ellen Barker and how that's going to fit into character evidence or previous relationships or what she's going to say about specific instances about Johnny Depp versus Amber Heard's past and prior relationships. I don't know what she's going to say. I haven't seen her testimony. Let's wait until we see it at trial before we really break down what Ellen Barker says. Okay? And that leads us to the end of the boring legal lecture there. So for those of you who didn't enjoy that, I apologize. But for those of you who are here just for the title of the video and the little chunk at the beginning, I like to start out with that before we get to the questions and kind of go off the rails wherever you guys want to go on these questions. So we are done with that portion now, and we will take a second to talk about the channel, and then we will get to the questions. So a lot of questions every time in every chat. Are you a real lawyer? Yes, I'm a real lawyer. I'm a civil trial lawyer, and this Johnny Depp and Amber Heard case is a civil trial. So that's why I'm breaking it down. I do this for a living. I am not a content creator as a job. I am a lawyer full-time as a job. I practice in Tampa Bay, Florida, personal injury, car accidents, wrongful death, catastrophic injury, premises liability cases, slip and fall, things like that. We also do a lot of criminal defense here as well. So that's what my firm handles. And we do it across the country, but we have a lot of colleagues too in other practice areas that people have reached out from the channel and we connect them with, and we try to help everybody as much as we possibly can. Thank you, Jody. Because we want to be a resource. That's why we started the channel. It's called The Lawyer You Know, so you can get to know a lawyer to answer questions for you. That was kind of the point of the channel. So, and then we also break down these cases so you can learn more about the legal process. People are asking me who Ellen Barker is. I don't know. I think it's a previous relationship of Johnny, but I honestly have no clue. So, Caitlin, I see your question in there, and I really just don't know. Oh, it's Barkin, not Barker. Sorry. Ellen Barkin. Exactly. This is my point. I have no clue who these people are until they come and testify. And once they come and testify, I will have an opinion on their testimony and what they say. I see people correcting me. Thank you, Ellen Barkin. This is just shows my ignorance to all of Johnny's past relationships and the people that have not been called yet in this case. All right, Smeely81. Hi from Norway. Love your channel. Thank you. In your opinion, do the lawyers from both sides play by the rules of court? Johnny Depp's lawyers, absolutely, I feel like, are playing by the rules of the court. Amber Heard's lawyers, I feel like, I'm not saying they're breaking the rules or cheating or something like if you're not cheating, you're not trying, but I think they're trying to do everything they can to go up to the line if they can. It seems like they're violating court orders pre-trial at least, but that may be Amber by not turning over certain evidence or metadata. And I don't think that when they're impeaching improperly, at least in my opinion, who is a, not saying I'm a way better lawyer than them or no way more than them. I'm just saying Rottenborn does not impeach the way I would impeach or the way I was taught to impeach or the way I impeach in trial. But I wouldn't say that's not playing by the rules. I think that's stylistically or maybe just doing it incorrectly. So I would say overall, yes, I think they're playing by the rules. There have been other cases where I haven't felt that way. Ryan Woodsmall. So I think the real question on everybody's mind is, what's your hair care routine? My hair care routine is to wash my hair with shampoo. Once in a while, I use my wife's conditioner, and I use this I use some hair product I get from Amazon for as cheap as I can find to keep it out of my face. That is my hair care routine. But I've been sent some stuff for beard care and soaps that's really taking me to the next level. And I used the soap for the first time today. I'm waiting for the beard to get in a little bit more before I use the beard oil. So maybe I'll have a beard care routine for you soon. Alejandra Garcia. Hi, new sub here. Can they use transcripts of audios that can't be played in court? Yes. I don't know what you mean by audios that can't be played in court. If they had the audios, they could be played in court. But I think you mean, can they use a transcript of a deposition instead of the video? Yes, you can have the transcript read in. You can enter a transcript into evidence if that witness is unavailable or the court allows that witness to take the place of or that transcript to take the place of the witness. But usually they have to have been deposed, so the other side has had the opportunity to cross-examine them. Are you stuck step attorney? I don't know what that means, but thank you for the super chat. Sharon Bodemede, thank you for the super sticker. Heather Hanks, should Amber Heard's juvenile DWI, which killed her best friend, be brought up as she was drinking at an early age only because she brings up Johnny Depp's drinking? So this would fall under, as we've talked about before a little bit, with what should be admissible or inadmissible, this would fall under substantially more prejudicial than probative. Like, what does it actually prove as far as relevant evidence? And if you want to say to rebut the fact that Johnny Depp's drinking, I think they can get that out in way less prejudicial evidence than the fact that she was potentially arrested and her best friend died and it was DWI, because potentially the jury would hate her just for that. And it could affect how they feel about her in this case, which would not be fair and what we would call unfairly and overly prejudicial, I would think. I don't think that should come in, personally. Leslie McAnally. It's amazing how I just forget how to read names on this. They just seem like a different language. Thanks so much for the great content. It looked like Ben Chu got excited when AH said, my dog got bit by a bee. Any theories as to why? Every time lawyers get excited, my theory is, especially this late in the case, after they've already put on their case in chief, is this is opening the door to new evidence that they didn't think they were going to be able to get into, either to impeach her and make her look like she's telling lies, or that they can bring another witness that's going to give some good testimony for them. That's my theory. What that is about the bee and the dog, I have no idea. Are you stuck, step attorney? With all the info out, would you consider AH a bad/hard client? And who do you see a lawyer would find easier to work with in this case? Johnny Depp seems to have a better relationship with his lawyers than Amber Heard, just kind of watching at trial. But they both kind of seem like difficult clients, if I'm being honest. This entire case seems difficult. I don't like character and assassination and mudslinging type cases. This feels like a family law divorce case almost. So they both kind of seem difficult, but that's more because of the case. The only thing I would say that would make Amber Heard a bad client is if she's lying to them. I'm not saying she is, and I don't know that she is. I'm just saying it's very difficult if you're trying to represent somebody and they're not giving you the whole truth. But generally speaking, she doesn't seem difficult to me in court. Peggy Wolf, do you think Johnny and his team knew she was going to say all the sexual stuff? Thanks for what you're doing. They didn't seem surprised. And I know she's made similar allegations before, even if it is a little bit different or nuanced from how she explained it before. So I would say I don't think that they were surprised. YouTube, Google. So are jurors random people with no education or law or anything? That doesn't seem right. I don't know. Yes, they are random people basically. And they usually, if they have education in law, they don't end up on the jury. It seems like you disagree with that. Be your own strong. Extremely unlikely, but what would you do / how would you react if you were a lawyer in this courtroom from either side and Amber Heard on cross just cracked and said, I lied about everything? So you'd have to, and this is a good question. And if we worked together and you asked me this, that would help because I would be able to reflect and think about it before it happened. Because in the moment, I would do one of two things. I would just say thank you, and I would sit down and be done. And then when they came on redirect, if she went back on that, then I would ask the judge to allow me to recross because she just changed her statements. That would give me another opportunity to kind of rehab myself. And if she changes her mind after saying she just lied. So it's either you do that and you just sit down, or you double down and say, you did lie about this. You lied about this, didn't you? You lied about that. You lied about that. You lied about that. But you run the risk of her saying, no. That's not what I meant. I meant I lied about everything, like how much I weighed or something like that. So those are the two ways. I would probably try to sit down. And then if they rehab her on redirect, I come back up on recross and get back into it. Ronald P59. Peter, I'm so jealous. I've always wanted to be a trial lawyer. Be honest. Do you wish you were on this trial? Absolutely not. I am not jealous of these lawyers being in this trial. This does not seem that fun to me, to be honest with you, to be in this kind of a trial. Alejandra Garcia. I think the thing with the dog is because currently there's an ongoing investigation about the dogs in Australia. She might face jail time for perjury there. So, but I wouldn't think that a bee biting the dog, or even Johnny holding the dog out the window, or even the dogs pooping in the bed. She's had a lot of references to dogs apparently. I don't think that's going to open the door to the perjury charges or anything going on with her dog in Australia. I really don't think that's going to open that door. Rock TV. If your wife pooped in the bed, what would you do? Sleep somewhere else. That's for sure. Colin McLennan. What if the jury believed Johnny but don't think it reaches the legal threshold to find against Amber? Can they still find against? So if they don't think it finds the legal threshold, then they can rule for neither of them. And they can say on the claim, we find for the defendant Amber Heard because we don't find that he met the legal standard for defamation. And on the counterclaim, we find for the defendant Johnny Depp, 0 damages going each way. I think that's a realistic potential outcome. Nancy, what's the difference between impeachment and perjury? Impeachment is an inconsistent statement that you put in front of the jury saying, well, you said this at your depo, but now you're saying this. Usually it's not in direct contradiction, but sometimes it is. Perjury is when you're actually arrested, prosecuted, and convicted of the crime of lying under oath. Sadiq Farouk, do you teach law classes anywhere? If not, any plans? I do not. University of Tampa actually asked me to teach some law classes in their entrepreneurship program, but I was not able to with my schedule. I don't think I ever will, but who knows? Taylor Pasternak. In your last video, you said something about Amber Heard's team questioning Johnny about what he told him. Can they do that despite attorney-client privilege? So certain things can get around the attorney-client privilege. And if it's been waived, if the attorney-client relationship has been broken, so they could potentially ask him some of that. Now, what he can say is that's attorney-client privilege, and they can object to it, but they can at least put it in front of the jury and say, did you tell him this? Did you say this? Now, the best way to get around that would be, have you told any of your agents? And we can put your attorney aside. And Johnny's probably going to say no, would be my guess. But you can say things like, yeah, have you told any of your PR team or anybody this about Amber, that she was lying or that it was a hoax? I would guess he could say no to that if he wants, but he's kind of already said yes, and he called her a liar basically in a trial. That's the whole thing about all this. Neither one of them are really denying saying what they said. So, whether or not, and again, it may not be attorney-client privilege if he says you directed your attorney to tell the media this. That may not be covered under attorney-client privilege. So we'll see. I don't know the rules specifically in Virginia, but definitely an objection that Johnny's team has and will continue to make. Ashley Oaks, are you a fan of Tom Brady? Absolutely. I was not very good, but played quarterback in high school, so I've always been a big fan of quarterbacks. And of course, I'm a fan of the Tampa Bay Bucks hometown team. So I was a fan of Tom Brady, Peyton Manning, Brett Favre, all those guys. And when Tommy came here, it was like perfect marriage, although I felt the same way when Jameis Winston came here because I'm a Knoll too. That didn't work out as well, but stay strong. I am totally late. Arg. Hi. Question, is it common for a week break mid-trial? No way. It's totally uncommon for them to take a week break in trial. Laura Diaz-Otten, what states are you licensed in? I think, so there are multiple states that we have some reciprocal license in. I know Florida and Washington, D.C., our firm has it. I'm trying to think if New York, potentially New York, I don't know. But there's something called Pro Hoc Vice where you can practice in different states on specific practice areas or lawyers you can refer to in other states. And right now we have cases all over the United States with different lawyers that we work on, mostly in the personal injury realm. Soap and Clay, not JD related. Any contacts for auto accident attorneys in Washington State? Yes, email me, lawyer@gmail.com. Email me and we'll talk about it. Riker Ryan, sorry. New member. Wayne Lang, first ever member. Thanks for the super sticker. Cello Mamba. What does it mean to sanction someone in law? So sanctions can come in a multitude of different ways. And actually, the Florida bar is rewriting some of our sanction rules. So I've been in the thick of it, actually. And I was on the committee talking about sanctions. Sanctions can come in the form of fines, meaning money, jail time, being thrown in jail, putting a freeze on some of your assets, potentially, if you're a party, or striking certain claims that you've made in your lawsuit, or even throwing your lawsuit out and losing your case. That can be a sanction or a punishment. There are all sorts of ways that you can be punished for sanctions in the law. Mo, Defendant's Exhibit 512 was brought into evidence as part of the 3/7/15 event. It was from December 15th in LA, not from Australia. Does that put more credence in the metadata issue? So unfortunately, I don't know which piece of evidence you're referencing, but I guess I can answer the question generally. If they bring it in, so you're saying they brought it in while she was describing the 3/7/15 event, but it really actually wasn't, or it was from December 15th. That's got to be taken up in cross and in closing, and those dots have to be connected by Johnny's lawyers to explain that to the jury, how it's not as it may seem. Melissa, if AH's lawyers think they're going to lose, do you think there will be any indicators? Do you think it's possible they already knew they were screwed before she took the stand? Usually you have a feeling whether or not you're going to win or lose, but it seems like their side, I'll say, won in the UK, so maybe that gave them some confidence, but they knew it was going to be very different here, not a bench trial and different laws, obviously. And I don't know if they knew it was going to be quite so popular or televised. I heard that they were fighting against that, but I don't know. I haven't gotten any indicators that they think they're going to lose, personally. Bodie, do lawyers like jurors without an education, period? No, I would not say that. And I would definitely say it depends on the case. So sometimes we don't like, like in a personal injury case where we're dealing with medicine and injuries and billing and things like that. Sometimes we don't like somebody who works in medical billing at a hospital or works the front desk at a doctor's office, because maybe they will sway the jury based on something they bring in as to how they think medical treatment should go versus on how our experts explain it or how the law is. So we're always kind of wary of people that have like education or experience right in the area we're talking about. But just the fact that somebody has a master's or a doctorate or a high school education or college education, that doesn't. My mic just cut out, so hopefully you guys can still hear me. Judy Seether, thank you. Vivian Wright, thank you. Alex Gorham, does her whole testimony get thrown out if she's impeached? No. You can have parts of it struck if usually that's during an objection, and you can have part of it struck, but it doesn't get thrown out. No. Alejandro Garcia, I meant the audio like the one in Australia. There's more people on the audio. Oh, I get what you're saying. So if they transcribe the audio and they enter the audio instead of video, we've actually had this happen before. We've done it two ways. We've actually had the transcript play at the same time as the video, but with the captions or the audio or the transcript typed out. So sometimes you can. There's got to be something with that audio or video. I haven't read all the pretrial motions, so I don't know what the issue was, but there has to be some issue with that as for it not to come in. And I don't know all of what it is because, again, I'm trying to focus on what's actually coming in. T.S. Duff. Having once sat on a jury myself, that's awesome, great experience for the channel. I know that there is much information that the jury is unaware of. Do you think JD's team will bring up the possibility of Botox and makeup causing her bruises? They would probably have to have an expert explain that you can get bruises there from Botox. And Amber would have to admit that she's had Botox before that stuff becomes relevant and you would even be able to get it in. So, we'll see. But yeah, there's every case. And that's what I've been saying on this case. Every case, every trial, there's so much that the jury doesn't see it or understand or know because it's not admissible or authentic or credible. So we've got to, be careful of that. International Mind. Why can this trial be recorded and released to the public and most trials don't allow cameras? Most trials in the United States do allow cameras. It's just this trial is getting so much attention being streamed everywhere. In federal court, they don't allow cameras or trials to be streamed, I should say. But a lot of trials do have CCTV video that you can watch in the courtroom. They're public, so you can get open and go to see it. And there's got to be a public interest. And I think the fact that Johnny Depp's lawyers potentially said this has a public interest for the cameras to be in here, and that might be why it's being streamed. All right, Martin Sinclair. Hello, I don't understand how the depositions work because the ones that were presented recorded in 2020, 2021, but the lawyers, the outcome before the trial. I don't know what the outcome before the trial means, but if you have a deposition, it's sworn statements under oath. And I think in Virginia, you can't subpoena and force a witness to show up. So if they refuse to show up, then you can play their depo. And here in Florida, if a witness is unavailable for a number of different reasons, then you're able to play their depo. So a lot of times that's why depositions are being played or read instead of somebody coming live. Thank you for the question. Riker Ryan, did you hear AH fans doxing YouTubers? I did hear that. I heard it's happening to Tug. I think it's a PR battle that you got to kind of accept is going to happen. Shout out, Cats fact finding next week from the UA. I'm sorry, UK. I don't know why I said UA. Alina Rivers. Shout out, Cats fact finding next week. Lethal Latin. DUI becoming more real. Killed best friend. Kimberly Wilkinson, thank you for the super sticker. I've noticed Amber's PR team in every YouTube comment section right now. Same comment on all the videos. Your thoughts, why the damage control? What is the comment? Because I haven't seen the comment. But I mean, yeah, I think I've had people kind of come at me saying they support Amber and I'm so biased. And like, I don't think you've watched all of our videos if you think that we're so biased and hating on Amber, because we're really not. We're literally just talking about how it might be inconsistent with certain other things or other evidence. And I have like every trial, there's somebody whose testimony is inconsistent. I'd say either you're lying or everybody else is lying. That happens in like every trial, not just this one. Thank you, Denny. Thank you, Trickster Factory, for the super sticker. Xavier Hickson, is there any way to salvage your defendant's case if they commit grievous perjury? Usually not. If they've been, charged with perjury in the middle of your trial, that's not usually great. Preston Accord, do you think this break gives Amber an unfair advantage to prepare for cross? No, I don't. I mean, I don't really think it's an unfair advantage either way. I think if Amber would have hit a home run and the jury left and that's all they were thinking about, or if she would have crashed and burned, then, it would have been a benefit to Johnny Depp's team. But I think she kind of did par for the course, what a lot of people expected. To me, she went big, and if they think that she exaggerated, that might not look good, but I don't think she crashed and burned by any means necessarily. So I don't really think anybody has a huge advantage. If I had to pick, I'd actually say I think Johnny Depp's team has a bigger advantage with the break, because they already had 4 weeks to prepare for cross if they wanted to. But Johnny Depp's team didn't have 4 weeks knowing exactly what Amber Heard was going to say on the stand. Now they know exactly what she said on the stand, and they have a full week to do nothing but prepare for cross. Is it illegal to film / record another person without permission in their state? How can they use this as evidence? So I think in California it is, in Florida it is. I don't know about the Bahamas or Australia or any of those jurisdictions. And they can use them if the judge says they can use them. And I think it may be because some of these videos already went public. And some people have accused, I think, Amber of selling it to TMZ. I don't know any of that, so I don't want to corroborate any of that or say that any of that is true. But if it was actually a illegal recording that resulted in a felony, I don't think the judge would let them use it, unless there was some other way they got the video. C. Randolph, do you think Amber Heard will claim that she had to use a surrogate mother to have her daughter because of SA damage? Is it hearsay if a physician does not testify? I don't know what that second question is asking specifically, but I would be shocked if Amber Heard made that allegation that she can't have children, because that is something I think she would have already had to make that type of an allegation. And Johnny Depp's team, she would have had to submit to a compulsory medical exam to actually prove that that's physically accurate and medically accurate. Grimish, thank you for the super sticker. I see Tarantula and a bunch of people saying that they think it's like Accutane has something to do with this as well. You're not the only one to have said that. A lot of people have said that. Let's see what else we got. Thank you, Kit Kat. Like and subscribe if you haven't already. We're on the road to 100K, which sounds wild to say. Wild to say. And some people are pushing me to a little promise I may have made on the last live stream if we get to 100K. We'll talk more about it if we get closer. It's got to be by the end of this trial. Sweden, can you ask questions that touch evidence that's not admissible, like content on an audio recording? No, you can't reference inadmissible evidence. Brittany, why weren't they striking objections? You have to object to something. It's basically, you've heard, right? When a witness is answering a question, and actually Johnny's security guy, the former cop, was the worst at this. He would hear the other side object and he would still try to get out his question. If the judge sustains that objection, then you can ask for what he said to be struck in response to that question. You can't just strike their whole testimony. Struck, stricken, whatever. What does Accutane have to do with anything? The redness on her face, I think, is what people are saying about. Again, I have seen no evidence of that, so I don't know. People are just trying to find why she has redness on the face or why she may have a bruise other than getting hit. Mags, at what point would perjury charges be made if clear during trial? Very unlikely for it to happen during trial, because let's say she says this and she wins, then does that mean that what she said was the truth because the jury believed her? So it wouldn't be perjury. Perjury, usually you have to, like somebody said, what if she said, I was lying about everything on the stand? How would you react? If she said that, then you might expect perjury charges from her prior statements. But right now, I don't think anything's really moving towards perjury. Mandy Bishop, is it normal to put a time limit on a case? A time limit, yes. Like this trial is going to take 4 days or 5 days or 6 weeks, which we talk about that in the pretrial order. Both sides agree and the judge agrees, so we can all plan for it and get on a trial docket. What's abnormal to me is, and it shows kind of how catty this has probably been between the parties, is they literally have to have the same amount of minutes and seconds. Usually we don't, and usually the plaintiff always spends way more time on a case. Like we usually spend twice as much time on a case. We'll call 10 witnesses and the defense will call 2. But on this case, it's minute for minute, second for second. William Wofford, did you hear that AH is facing perjury charges in Australia over the dog incident? Yes. She tried to force people to lie for her and take the blame. Melcher was talking about it. It could come out and cross. I don't think it's going to come out and cross. Now, listen, crimes of moral turpitude or that are for trustworthiness or show your lack of honesty, those can usually come out, but only if you've been convicted, not just because you've been accused of something. I'd be surprised if the judge allows accusations of perjury to come out in this trial. And I've tried to stay away from some of the stories, but again, a lot of tweets I've been tagged in this type of stuff, and she's blaming Johnny for that, saying he let her take the fall when it was really his fault, and et cetera, et cetera. But again, I don't know how reliable it seems. Elaine McKenzie, the behavior panel all agree Amber is being highly deceptive. They're a group who have worked for the FBI. Interesting. And I've seen other people say similar things. Smile Instructor, does the defamation trial only consider the op-ed, or would it now also take the calumny statements? I don't know what that means. In account now after AH was on the stand? Nope, it's just the op-ed. That's what's in the complaint. That's what they have to prove. Those are the jury instruction and verdict questions that the jury has to answer. Stay strong, new member. I thought you already were a member for some reason. Thank you for everything you do for us laymen to understand the law. Thank you, Jackie. Brenda, what happens when the lawyers approach the judge during trial? I'm always curious as to what they're discussing. So a lot of times there's a lot of things they can't discuss in the presence of the jury. So they go up to the bar for a conference or a sidebar, and they'll discuss whatever is not be able to be discussed in front of the jury. And mostly this is what they discuss. Objections, why it should or shouldn't come in, why this evidence is inadmissible, prior rulings by the judge, things that have happened pre-trial, stipulations the parties have agreed to that the jury might not know about. So they go up there and they say, Judge, we agreed we weren't going to get into his kids, when they object. But they don't want to say that in front of the jury, because the jury may think, why aren't they going to get into his kids? Why don't they want to bring that into it? Or they say, Judge, you ruled we weren't going to talk about the UK trial. They don't want to say that in front of the jury, so they go up to sidebar and discuss it. Eva Hook. And those sidebar arguments are also transcribed into the record in case they come up as an issue on appeal. Eva Hook, can the jury watch social media clips of the trial, social media or clips of the trial? No. And in this case, they really shouldn't, with all of the stuff that's out there right now, which is all over the place. But the judge tells them not to. And if they come back and say they did, they're out. And if so many of them did, it could potentially cause a mistrial, and we have to redo the whole thing. Chrissy Curry, can you talk about Amber's counterclaim, and is the public calling her a liar and making crude videos helping her claim if Johnny loses? That's basically her counterclaim, right? Is that Johnny and his agents came out and said it was a hoax and she was a liar. Very hard to win a defamation case like that, even harder than Johnny's potentially. Because, again, constitutionally protected opinion. So I don't think she has a very strong claim personally. I also don't feel like we've seen almost any evidence come out through the first almost 2 witnesses of Amber Heard's case in chief. So if she's going to prove that claim, we hopefully are going to hear evidence of that. Solange Pena, aren't all these YouTube videos actually helping them? No, I don't think so. First off, it's not discriminatory in who they help, right? If it was going to help one lawyer, it would help both. But I don't think they're watching. I don't think they care. I think they have plenty to do and work on this case. All right, we've got about 10 more minutes in today's video as we're getting up on the hour point. So we'll answer a few more questions on the way out here. But thank you, everybody, for coming in. And if you haven't subscribed yet, take a second to subscribe. I think I already mentioned this off the top. We are going to do a giveaway for the 75K, but you have to be a subscriber. We're going to post a question on our community page, pick a random winner, and send them a Trago Stars and Tragos t-shirt. And if we get to 100K, we're going to do a lot of stuff. It's going to be big giveaways and other fun stuff as well, which we can discuss as we kind of get closer. Thank you, Jody. Thank you, Holly. Let's see what else we got here. David Davies said, get fitted for that pirate costume. All right, Beth McCleary. Why was Johnny able to say what he said, but when Amber tries to say what she said, it's considered hearsay? Thanks, love the videos. I actually think that the judge was wrong in sustaining some of those objections. I do think she can say some of the things that she said. Now, what she can't do is bolster her own testimony by saying, oh, and right after that happened, I said, because that's just trying to make it seem more truthful because of the timing and the contemporaneous nature of how she said it versus just saying what happened because she was there, right? She can say, Johnny hit me, he threw me on the bed. She doesn't have to say, he hit me, and when he hit me, I said, Johnny, I can't believe you hit me like that. You said you would never hit me. Quoting herself like that to bolster her own testimony isn't going to come in and is hearsay. So those sustained objections I agree with, but just everything that she said or that came out of her mouth, there are exceptions to some of those that I went through on the top of the video today that I think some of that actually should have come in. But I think Johnny got objected to and some of that stayed out as well. And certain times Amber's lawyers did not object to him saying what he said. So that was some of the reason it came in. It seemed like the judge was just keeping everything out that somebody said, I said, or there was something that indicated hearsay. Janine Lee, do you think it's smart for AH to have local lawyers? A lot of times people think local lawyers have the leg up on other lawyers, but I don't see correlation necessarily in this case for that. Daniela K, just wanted to say you're awesome. Thank you. Found you through Legal Bites and instantly subbed, became a member. Awesome, Daniela K. Thank you. Jilly Stalder, do you have a graphic designer who designs your merch? No. Do you need one? Maybe. I am one. Shoot us an email, lawyeryouknow@gmail.com. Dave Van Helsdingen. She did commit perjury. She said to have slapped someone for the first time in her life in 2 instances at the same testimony. I have heard some of this, but it seemed to me like she said it was the first time Johnny had ever physically hit her, not ever in her life. And that's the problem with perjury, right? So if she said that and the cops arrest her and she's getting prosecuted, she said, what I meant was the first time Johnny hit me. I'm sorry. It was just a turn of phrase. I was under a lot of pressure. It was a slip of the tongue. I did not mean to lie. That's why it's so hard to convict somebody of perjury, because if they can dance around it like that, usually law enforcement doesn't want to take a case like that, or state attorney's office. Halvers 1, do you think that Depp team is going to ask questions that she is going to lie about, but they can't show evidence in court that she lied so the public can see that she is just clearly lying about everything? Do you think Depp's team is going to ask a question that she is going to lie about, but they can't show evidence in court that she's lying so the public can see that she's lying? So you're saying, are they planning for public outrage and for the public to call out these lies and find these lies? I don't think any lawyer would ever rely on that. Now, are they going to ask her questions that they think she's going to lie about? Probably. And then they're going to try to impeach her with those lies, would be my guess. Jordy W. Off topic. West Boys in California. 2 adopted kids go missing. A year later, grand jury indictment of parents for murder. What's the difference between grand jury indictment and regular charges? Also, no body case. Is there enough evidence? When no body, usually they say that's a very difficult case. Every state is a little bit different. Some have grand juries. Sometimes law enforcement just makes the determination to do an indictment. Sometimes grand juries are secret or private. Every jurisdiction is different, but a grand jury is just brought the evidence in the case, and it's a probable cause standard most of the time. I don't want to answer for every jurisdiction, but they find out, instead of beyond a reasonable doubt, we're convicting this person of the crime, it's, do you think we have enough probable cause to go after this person, arrest them, and prosecute them? You make this decision before we, the prosecuting attorneys, can do it. So there's no real difference once the charges are brought and the indictment is brought down. Nancy Webb, it's just how you get there is different. Calumny defense is a legal term for defamation. Okay, I've never heard that. Accutane is a drug that causes birth defects. It's for acne. I know what Accutane is. Stop showing new subs, as people can unsub and sub again to get TV times. Whatever. If they want to do that, then okay. Martine Sinclair, question. When I was talking about the depositions, that the lawyers already know the outcome of the deposition before the trial begins. Absolutely. And that's great. And a lot of times that helps and makes it easier for us to prepare. So we probably have at least one video depo that's already done prior to the trial starting. And it does make it a lot easier to prep for opening, to prep for closing, to prep cross-examination of another expert or things like that. So yeah, it is kind of a useful tool, but a lot of times it's kind of boring. So we try not to do it too much because we don't want to bore the jury. Riri Yanni, thank you for the super sticker. Bob B, who decides where the parties sit in the courtroom? The prosecution and the plaintiff. Prosecutor in criminal cases and the plaintiff in civil cases usually sits closest to the jury, and the defendant or the defense sits further away from the jury. And we have our counsel table and sections here, and then the gallery directly behind the client is usually supporters of the client they're sitting behind. Stay strong. How are you able to focus on so much plus your own personal clients? So I listen to a lot of podcasts and music and things like that while I work. So I've basically been listening to the Johnny Depp trial and Amber Heard trial on 2x speed while I work. And that's how I kind of listen to that. So I don't catch every single word. There may be a thing I miss here or there, but I'm still full caseload. Full-time lawyer will always be. And for lives like this, where I do an hour and a half, I block it as a section of my day, or at night. I do a lot of them at night, which obviously is, after work, after my kids go to bed. But I schedule it just like a telephone call or a meeting. So when I have time, I plug it in. That's why my lives are kind of all over the place. They're not always the same time every single day, because I try to fit them between appointments. Nicole Davies, appreciate the fact you continue to be unbiased and still deliver a great show and have an open mind. I can't wait for Monday to come around. Thank you. Yeah, it's going to be fun Monday. Kesa Dilibar, is it possible that Amber Heard's side can still pull out a huge Uno reverse card and turn the whole tide? I think if they would have done it, it would have been with Amber. And I think maybe that they thought that's what they were doing with Dr. Hughes and Amber kind of back to back. But I think she's got to win the trial for them on the stand, and it could happen in cross. That's why I think cross is going to be so important, which is why I think my dad and I were setting everything up possibly to where we can actually live stream and comment live and discuss the cross and our live reactions. I'm trying to block as much of those 2 days as I possibly can. Again, I'll have to jump off for some calls and some meetings and stuff that I have. And this is why I can't live stream a trial for 6 weeks, but maybe parts of a trial. This is going to be kind of a test for us. So bear with us as we, get our bearings and try to do it. But I think we are going to try to do that. Lisa Girl, will you be giving insight to the Daybell Valos? Yes, we have a whole playlist on our channel already. We've done a bunch of videos on that case, and we will continue to follow it. That's been of interest of ours from the jump. So we will absolutely be doing videos on that case. And I actually recorded the kind of primer to Dan Markel's case, the murder trial of the FSU criminal law professor where I went to college, where I went to law school when I was there. So our primer is going to be running, I think, tomorrow after the live directly. So a lot of you are interested in that. So make sure you check that out when we post. Hit that reminder bell and subscribe. Johnny's Girl, can Johnny ask for her case dismissed? They can ask for a directed verdict probably after she closes her case in chief, but I would not expect them to win that. I think the judge is going to let this case get to the jury. All right. Yes, Trish, we are covering that for sure. Jordy, thank you so much. Yes, this was fun. Again, as always, make sure you check out our page for the giveaway. We're going to do another live tomorrow. Post in the community page what you want the content of the beginning of that live to be. It can just be a full hour of Q&A if you want. That could be fun too. But, Alma Nichols said they almost forgot to hit that like button. Make sure you don't forget that. But that's all we've got for today. We'll be back tomorrow for another live. And like I said, the Charles Adelson, Dan Markel trial intro or preview will go and drop tomorrow after the live. So tomorrow afternoon, check us out. Be here or be square. I'm out of here. Thanks for everybody that was able to join.